But with that matter, I'm for the applicant. My addition of party application matter is yet to be disposed of. But every occasion I lost my chance, my lord.
That is not the case. The case is that nobody can be blamed.
But I missed my chance. But I'm missing my chance. Every day I'm appearing. You lost many
Today also, your adversaries cannot be.
If you say Cali take it about 2, I shall intimate the other side. If they otherwise ready, then the matter can be application can be disposed of.
Intimate your adversary. If it can be fixed earlier, then the matter can be taken up now even or at 12.
At 12 minute, I shall inform you. Much of. Much of best.
Possible. Yeah. Possible.
My lord, I have for the respondents. We had completed our arguments. The appellant was supposed to give a reply. I do not believe appellant is here. I haven't heard from the appellant. My lord, if lordship can fix it too, my lord, I can try and reach out to the appellant.
Why not earlier? Intimate
It will be a little difficult to get hold of
intimate
the
your
appellant.
adversary. If it can be taken up earlier, then well and good.
I'll try and get hold of him, my lord. I'm sure to it.
And be kind enough to inform.
Yes, my lord. Absolutely.
For item 5. Is 100.
আপনি ডাকুন আপনি আস্তে আস্তে ডাকুন
My lord, is 100 so is my lord, we were to file written notes of argument that has been prepared by my learned senior counsel, Mr. Mojumdar. He was also here yesterday, but today he has got indisposed and could not come to court. It's lying with him. Kindly make it not today. One
So,
chance.
it cannot be taken up today.
No. He is to make advance argument on certain points, and he has also prepared detailed notes of argument.
Probably this bench will be available on Friday during the.
I will tell
during
you.
the
I have
second
also
session.
telephoned him
Probably.
only few minutes back.
Probably it will be available during the second session on Friday.
Right, very good.
Get
Okay.
prepared and.
Certainly, ma'am. Only not
100.
Friday after today, next sit. Right after today, your lordship will be.
Whether this bench will be available on Wednesday or Thursday, I don't know. But Friday during the second session, it will be.
Grateful.
Item number 5, not today.
Number 6. Item number 6. Number 8,
So item number 8, I appear for the panchayat.
For orders.
Lordship was
It will be,
reserve the matter for judgment.
it will be, probably it will be passed on Friday.
Lordship.
number 9,
Seven to 2025.
number 30, 12, 13, item number 14, number
Item 50.
My lord, I am for the petitioner, Mr. Pingal Bhattacharya appearing for the petition. My lord, he is on his leg. My lord, going for very short pass over. Just coming.
number 16,
Password. 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 Number 15, my lord. 15, my lord, what happened, my lord? I am for the petitioner. But what happened, my lord? What points they have taken in their affidavit? I have to withdraw the writ petition with liberty to file a fresh, my lord. I am praying for withdrawal of the writ petition with liberty to file a fresh. My lord. But probably they have not yet come. Let's fix it on Friday. If they don't come, your lordship has the liberty to. Your lordship can pass an order to that effect. Okay.
Item number 9, Your Lordship, I'm sorry, Lordship, I'm not missed.
item number 16, item number 17,
My lord, in this matter, I'm appearing for the appellant. We have obtained a change couple of days back. I was humbly praying for some accommodation, my lord. And there is an amendment application which has been filed. The original appellant has passed away here. The wife has filed an application for substitution of a correct one. Substitution, I'm so sorry. Substitution. Okay. I'm for that. In case my lord is taking up on coming Friday, the substitution can be allowed to, it has to be substituted. The original hearing can take place some other day. The substitution can be allowed on that day. The lordship will kindly make it not today. And no, there is only one application. The cause title has to be amended and then the hearing can be. Good. Yes, my lord, there is an order also. Has been heard, there is an order. So my lord is making it not today. Did it to Namta Niyanam?
Last of it was the body attack on the
16. Lordship kindly, 13th of February 25, Lordship's order. Your Lordship's order.
Let it be called during the second round.
Item number 18,
Be seated.
item number 19, number 20,
21.
21,
Your lordship made this CAV.
In the last occasion, written notes of argument were filed.
Were filed, everything given. The eviction of trespasser.
On 13th of February,
Mal.
already 7 days of passed by.
That's fine.
Item number 21.
21.
21 to the list has been out of list বাদ দিয়ে হলো judgment prepare হলে তখন judgment এ
So grateful to us.
I thought এটা পাঠিয়ে দেয়নি
He responded.
Item number 23.
Right, একটু appear for the response. Animesh Das. Animesh Das, we were told. No problem. Animesh Das is, was Justice Dutt's junior. I know him. Yes, but. Aman. This is also pending for a long time. Very well, Milord, if they come, Milord, your lordship will. Second call. I will do that. But Animesh Das's phone number I don't have. And আসে কি? এটা তো শোনিনি, আমরা বানিয়েছি। উনিশশো পাবি কিন্তু হচ্ছে 13 নম্বর বাড়ি বা ওই তলার বাড়ি।
Item number 24. Item number 25.
Milord, we try and
Item number 26. Item number 29. Item number 30. Item number 31. Item number 32. Item number 33. Item number 34. Item number 35.
35, Lordship, I am appearing for, on behalf of appellant, I am taking a short passover. I shall inform them.
Item number 6, I have put the board.
Item number 1. Item number 2.
Two, Lordship, I am for the appellant. Mr. Gopal Chandra Ghosh is appearing for the respondent. He has to complete his submissions. We have completed our pleadings. Lordship.
Number 3. Item number 4. 6. Item number 7. Item number 9.
Item number 9, Your Lordship, I am for the appellant, Mr. Kolil Basu. I am led by Mr. Kolil Basu, Your Lordship. Lordship, today, Lordship, kindly fix the matter on Friday. Lordship, today, I have not briefed, Your Lordship. The brief has not come, Your Lordship, today only, Your Lordship. After this, Your Lordship, no, I'm
On that day, I have to be present, Mr.
Yeah,
Murphy to be
definitely,
prepared.
definitely, Lordship. I will inform Mr. Shutobashan, Your Lordship,
This
I will-
Friday during the afternoon session.
during the afternoon session.
Intimate your adversary also. Mr. Banerjee and Ms. Khanna
Shutobashan,
were
I will-
appeared.
I will
That the
inform.
matter will be taken up on Friday.
I will inform.
Item number 10. Item number 11. Item number 12.
I am appearing for this statement. Report have been filed. Report filed.
But what can be done today in the absence of the other side? Only the dog could. One, two, three, and four. That is the state of West Bengal, district magistrate, and the superintendent of police, South 24 Parganas, and the inspector in charge, Narendrapur Police Station, district South 24 Parganas, is present. Full stop. As none is representing the petitioner, the matter cannot be taken up for hearing today. As such, it is adjourned for the day.
Madam,
Item number 13. Item number 14.
I am for the same.
14. Record. Brief text. 14. Oh, 82 channel.
Item number 16.
16. Malad, I have paid for the corporation. Malad, last order, Lordship, here, Lordship. Passed the order on 13th of February 2025. As you kindly see, we have taken an instruction that the appeal is pending before the special officer building.
Senate Council. Apart from a formal order that cannot be taken up on the earlier occasion.
Let the instruction be kept with the record, Lordship.
On the earlier occasion also, you have stated as because apart from on the earlier occasion, 13th of February,
13th of February.
you are representing
Here for the corporation.
Corporation, Kolkata Municipal Corporation. Apart from the Kolkata Municipal Corporation, none were representing on 13th. As such, no further proceeding cannot be proceeded. And on the earlier occasion, 12 also, the same thing. Be kind enough to intimate your adversary that the matter will be taken up on Friday.
Does it kindly pass this order so that I can communicate my authority?
Senate Council.
So Lordship knows though.
And submits that written instruction and submits that
Instruction with me, my lord.
Submits that instruction and submits that he is ready. He is ready with the instruction. Full stop. As none is representing the petitioner, the matter cannot be proceeded today. Full stop. Adjourned for the day.
I'm grateful, Lordship.
Item number 18.
Asif.
I appear for the defendant respondents. Judgment of affirmation, plaintiff's appeal lost in both the court. Now they lost interest. At one point of time, they started.
Yes, Lord counsels.
The appellant started, opened the case and they argued at length.
At length. So we will be, tin box, let the matter appear on the exit. The original deed, the counsel present responded until provided tin box. কি অবস্থা দেখেন। The original deed being deed number এত number এত Yes, argument had commenced
Yes.
on behalf of the appellant.
Yes, my lord, argument had commenced, my lord. But today, my lord, I am in difficulty, my lord. My learned senior clerks, my lord, has missed the brief, my lord, today.
না, আজকে তো রেগুলার বেঞ্চ
Regular bench
আমার কথাই না, সেটা কথা না।
So,
If you lordships, brief আসেনি? Friday, lordship is probably sitting.
probably sitting. Get prepared so that the matter can be taken up. If possible, it can be taken up on Friday.
Kindly record an order so that they can come prepared on Friday.
No, my lord,
Date cannot be fixed, but
it cannot be.
verbally, what do you intend?
No. What my learned senior friend is saying, my lord, that I am saying. Because your lordship, when your lordship
Why-
will sit, my lord,
What
singly,
is the
my lord,
intention by saying that date cannot be fixed?
it fell from your lordship that date cannot be fixed because your lordship is,
Will you utter that one?
I apologize.
Item number 18. The appellants are being represented while the respondents are also being represented. Full stop. ওনার নামটা নিয়ে নেবেন। Learned advocate representing the appellants seeks an accommodation for this day. Full stop. Let the matter be taken up on the next date when this bench is available. The matter will be taken up on the next date when this bench will be available.
When the appellant should come prepared and comments.
The matter will be taken up.
That is enough indication.
Item number 9.
Has the,
It was upgraded by your lord.
has the appellants started or completed? They have not started.
What you started?
Um, Can it be taken up today?
My lord, I don't know, my lord. We are for the respondent, my lord. Judgment for.
If both sides are available, the matter can be taken up today itself. Otherwise,
Then, my lord, in that case, my lord, we'll give a notice to the learned advocate intimating that.
that I am conveying verbally. Be prepared if possible, if this bench is available, then the matter can be taken up on Friday. Next,
Item number 22. Item number 23. Item number 24. Item number 25.
Finally, item number 25, I am for the respondent finally.
what is your adversary? In their absence, the matter cannot be taken up.
I may try to intimate them, my lord.
Try to intimate and inform this court
Mine.
as to whether they will be available today or not.
My lord. I shall.
Item number 26, 27, 28. Item number 29. Item number 30. Item number 31. Item number 32. Item number 33.
Item number 33, my lord, we are for the appellant, my lord.
33. For the
The
appellant.
predicament is, my lord, I have not brought the brief because I was not aware, my lord, the lord should be sitting. Therefore, my lord, kindly take it.
That is
Item number 34. Item number 35.
need not. Information দিলো না।
2025, my lord. Your lordship directed me to submit the written note of argument and type copy of the exhibits, my lord. And the appellant has also filed a written reply to my written notes of argument. My lord, I have made, may I submit, my lord?
The written notes of argument.
Your lordship has made this matter CAV on 7th February.
Mention a matter. In this matter, second,
Mention. Which one? Which matter?
it is not in the list, your lordship.
Next day you mention.
My lord, may I permit to mention, my lord, one matter, item number 4, my lord. The matter has been earlier on 13th of February. Both party argument has been complete. My lord was directed to submit written notes of argument. May I submit, my lord, today?
Each and every matter has been called twice today.
And I'm-
Where were you?
My lord, I'm at that time missing.
Be present on Friday during the afternoon session.
Great.
Your lordship, I just have one difficulty that the respondent's name in the second appeal that was admitted has been wrongly written. So I cannot file my wakalatnama. So that's the reason I was mentioning.
What to be done? Mentioning time is over. This bench was available from 11 AM today. You mentioned on Friday?
Faithfully, Your Lordship.
যে রেসপন্ডেন্ট যদি বলেন
I'm for the applicant. I also informed the appellant. Yes, my lord. But he's not present. No, my lord. Respond. So permit me, I can
May I permit to file an opposition, my lord, I have start copy now. I have
Just drop me a copy.
Only addition of party application.
Can four.
Six already.
Already disposed of, can, Honorable Lordship, kindly look into the last order. The order dated. Yes. Can four is regularized. একটা করবো না, এখানে 6 হয়ে আছে। আর দরকার কি আছে, আমারই তো কপি, আমি করলেন আর না
সেটাই।
আমরা তো বললাম কোর্টের কপিটা ঠিক আছে তো, কোর্টের কপি ওল্ড নম্বরটা। আচ্ছা আচ্ছা আচ্ছা, কোথায় টেন ফোরের তো ওল্ড নাম্বারটা আমার কাছেও
নাম্বার ছিল।
1827 1827 হচ্ছে ওল্ড নাম্বার, 20 মানে ওল্ড নাম্বার। can 4 এর old number হচ্ছে 1827. Can 4. There must be some mistake in the well, well,
Copy has been served, you have received.
yes.
Any more step to be taken on your part?
Because it's a pure question of law. Number
Yes.
may I give you also the short detail of the entire suit? The entire property was owned by one Siddheshwar Ghosh.
First of all, whether prior to this application,
Fine.
any application was filed which has been disposed of as regards to addition of party,
That is withdrawn.
withdrawn.
Withdrawn with the liberty to take steps.
By the order dated,
By the order dated 13th August 2020. Your lordship permitted us to. 13th August 2020.
13/8/2024.
13/8/2024, can 6 of 2020.
My lord, may I submit one thing? My lord?
Hmm.
It has been stated in this application, my lord, that the applicant filed an addition of party application, my lord, before the trial court, my lord. It
Yes.
has been stated in page 14, my lord.
That is with the trial court. Number, may I give you lordship the update?
Let him submit, you will get the opportunity
Number one,
to counter.
One Siddheshwar Ghosh was the owner of the entire farm. Number he died, leaving behind 3 daughters, wife and mother.
Do you have the genealogy?
My lord, last occasion, it was submitted before your lord. Maybe it's in the record. Number 2, he died, my lord, with a will. My lord, by that will, my lord, he given 3 daughters,
Siddheshwar Ghosh had 3 daughters.
3 daughters.
Hmm. Namely,
Sarojbasini, Ashalata, Sneholata.
1 minute.
And my lord, mother, Himrani, and wife, Charupala. Right, Didi?
So at the time of his death,
He leaving behind a will.
he left behind mother, spouse, and 3
3 daughters.
daughters.
Yes.
Name of the spouse?
Name of is Charubala.
Achha.
Number he left behind a will dated 21st July 1948.
Yes.
By that will, he given life interest to her 3 daughters
Achha.
in favor of her 3 daughters. On the
Life interest.
life interest. On the condition that they will
Probated. Will probated.
yes, will probate it. Will probate it on 12th March 1951.
And what about the achha. So at the time of his death, his mother had expired.
No, mother alive.
So as
By,
regards to
by
mother,
the will, he given the 3 daughters life interest with the condition that they will maintain the wife and mother.
achha.
And the sons and daughter of the 3 daughters
One minute.
will be
Probated on
12th March 1951. এই ডেটটা একটু ভুল হলে আমাকে একটু বলে দেবেন
1951.
1.
Yes.
Number but the entire ownership has been given to sons and daughters of his 3 daughters. 3 daughters will life interest. They will maintain the wife and mother. And after the death of the daughters, the entire property will be divided upon the sons and daughters of the 3 daughters. They will get the ownership.
Grandchildren.
Yes, grandchildren.
Absolute interest.
Yes, absolute interest. Number will was probated 12th March 1951. Number after probate of the will, 3 daughters, Lordship, settle before the arrest settlement, they amicably partition their property. They used to
Slowly.
smile.
Yes.
They recorded their name in the concerned RS Sarovar and they used their property according to Solwana share each, 1/3 share each.
In whose name it has been recorded?
The 3 daughters.
3 daughters.
3 daughters. Now, my lord, I am coming through Ashalata.
You are the
I'm coming through Ashalata. My lord, Ashalata has 4 sons. But since it has been given to the sons and daughter of 3 daughters, all will get 1/3 each, 1/3 share each. Now, Ashalata and her heirs will get 1.35 acre in RS plot number 707.
You have purchased from Ashalata or you
Through Ashalata, from the side of Ashalata.
you inherited?
Inherited in the heirs of the Ashalata.
You are one of the heir of
No, I purchased from the heirs of the
the heirs of Ashalata.
Ashalata. The heirs of the Asalata get 1.35 acre.
Now the question arises that in between Saroj, Ashalata and Hemlata,
Yes. They got only the life interest. They recorded their name and use as per their lordship the amicable settlement. There is no official
But you have
partition.
purchased from whom?
I purchased from Asalata died leaving behind 4 sons. Shosti Kinkor, Rabindranath, Sunil and Sridhar. I purchased from the 4 sons.
Now the question arises that whether partition took place in between the grandsons and granddaughters of Siddheshwar Ghosh or not.
Yes, Malad, that is the suit. That is the suit. In the suit, they himself admitted, I'll show you your lordship from the opposition, that the Siddheshwar died leaving behind 3 daughters. They have only the life interest. The parties before your lordship, the plaintiff and the defendant or the appellant, the respondent are claiming their right from the sons and daughter of the 3 daughters. I purchased from the sons of Asalata. I purchased 1.35 acre. 1.35 acre was possessed by 4 sons of Asalata.
1.35 acres from the name of the person?
Shosti Kinkor, Rabindranath.
Oh, from all the 4 sons of
Asalata.
Ashalata.
Asalata. Number, may I submit, but here, certain glitch is there. Not me. One Gopal and Shivshankar. Shivshankar is the Malad appellant, one of the applicant. Gopal and Shivshankar jointly purchased from 4 sons. One Gopal.
So, you along with Gopal.
Gopal. Now, my lord, there is a deed between Gopal and myself that Gopal, I gave other property to Gopal. Gopal in return give his share to me in the exchange.
Anything more left?
Now, I am the owner right now. I am possessing 1.35 acre, out of which 0.06 acre acquired by the government. Now, what I'm.
Where have you mentioned in your petition?
My lord, if you lordship kindly come to. Now, my lord, before that, I filed an application before the learned trial court.
Be seated. Be seated.
I have filed an application before the trial court. My lord, if you lordship kindly look into
Before
my learned trial court.
You had filed.
I had filed in 2018. In the meantime, the matter came up before this honorable court for appeal, and appeal court passed an order. So my application could not be taken up by the learned trial court. Because this is
I couldn't get
this
that.
is a partition suit. After preliminary decree, they challenged before the district judge the valuation. Thereafter, they came before this honorable court.
What was challenged? Preliminary decree was challenged.
Preliminary decree.
Share was challenged.
Preliminary decree was. That now that came before your lordship at the second level. The preliminary decree is there.
So there has not been any final decree.
In the preliminary decree, I filed an application for addition of part after passing of the preliminary. That application is pending since the matter came before this honorable court and the appeal is pending. You will also kindly see my application. That is page 28 of Can 4. The application before the trial court. Annexure B.
Page 23.
Sorry, Marathon. No, Marathon.
Annexure B. Annexure B.
Yes, Marathon.
Annexure B.
May I read for your lordship? The suit property originally belonged to Siddheshwar Ghosh. The Siddheshwar Ghosh died in Ashar 1356 BS, leaving behind 3 daughters, namely Sarojini Ghosh, Ashalata, and the given has been given. But kindly skip over because it's not required. The grant of probate has been given. Now paragraph 2. So the
Hold
effort
on, it is required for me because I will have to
go through the fact.
go
They will
through
also
entire
get the
fact,
fact.
otherwise it cannot be disposed of.
Everything has been all point by point has been written over there. Madam.
3 daughters and 2 wives.
But I say, my lord, is
Charubala,
and Puritosh Kumari. It says
Puritosh
so.
Kumari
Yes.
Dashi, and mother Hembaroni Dashi.
Himbarani Das.
Yes, the said Siddheshwar Ghosh. Yes, then council, place
Nay,
the paragraph.
that the said property generally belonged to Siddheshwar Ghosh. The Siddheshwar Ghosh died in Ashar 1356 BS, leaving behind 3 daughters, namely Saroj Basini, Ashalata, Sneholata, 2 wives, namely Charubala, Puritosh, and mother Hemrani Das. The said Siddheshwar Ghosh during his lifetime executed a will in respect of his properties on 21st July 1948, corresponding to 5th Shravan 1355 BS. The condition of the said will was that after the death of Siddheshwar, his aforesaid 3 daughters will enjoy his properties as life estate owners, and the sons and daughters of the aforesaid 3 daughters will be full owner of his property. There was also a condition that his aforesaid 3 daughters will maintain his wives and mother from the income of his properties. After the demise of Siddheshwar Ghosh, his said 3 daughters filed probate case number 88 of 2000, but it has been wrongly written in 2010, in respect of will dated 21st July 1948, and the said will has been probated on 12th March 1951. The said grant certificate of probate is under the custody of the plaintiff. That the aforesaid 2 wives, Siddheshwar Ghosh, died before
The
R.S.
said will has been probated on
12th March 1951.
was not 1951, yes.
That the aforesaid 2 wives of Siddheshwar Ghosh died before R.S. Arwa, and that after demise of those wives of Siddheshwar Ghosh, the suit properties were amicably settled among the co-sharers, and as such 3 daughters of Siddheshwar Ghosh got suit property in 16 anna share each exclusively, and their name have been recorded in R.S. Arwa. And on the basis of such settlement, the said suit property, plot number 707, exclusively allotted in the name of Ashalata Ghosh, one of the daughter of Siddheshwar Ghosh, who possessed the same to the knowledge of all concerned till her death without interruption from any corner. Subsequently, Ashalata Ghosh died, leaving behind 4 sons, namely Sosti Kinkor, Rabindranath, Sunil, and Sridhar, who inherited the properties left by their mother, Ashalata Ghosh, according to Hindi law of inheritance. That LA collector acquired to extent of 0 cent, 6 cent out of 1.35 acres in plot number 707 in LA case number 590 or 1991 for the construction of Panagarh-Morgram Highway Road, and the award of compensation money was given to the 4 sons of Ashalata Ghosh. That thereafter, one of the sons of Ashalata, namely Sridhar Ghosh, died, leaving behind his wife Gulali and 2 sons, namely Sudipto and Ashish, who inherited the properties left by their father, Sridhar Ghosh equal. The aforesaid Sosti Kinkor, Rabindranath, Sunil, sons of late Ashalata Ghosh, and the legal heirs of Sridhar Ghosh, that is Dulali Ghosh, and 2 sons, namely Sudipto Ghosh and Ashish Kumar Ghosh, transferred remaining 1.2 acre of suit plot number 707 jointly to Gopal Kejriwal and Shiv Shankar Kejriwal by way of registered deed of sale on 28 June 2002, white deed number 3663 for the year 2002. And on the basis of said registered deed of sale, the aforesaid purchaser got right, title, interest, and possession of the suit plot number 707 and paid taxes to the state of West Bengal, who after accepting the taxes recorded their name in the present LR and also paid taxes up to the Tilpara Gram Panchayat, and their aforesaid purchaser are still in possession of the same to the knowledge of all concerned. That said, Gopal Kejriwal and Shiv Shankar Kejriwal made a registered deed of Bonton Nama relating to suit plot number 707 along with other non-suited plot by deed number 245 for the year 2005, dated 6th October 2005, and on the basis of the said Bontonnamer deed, the petitioner inventors number 1 and 2 got the suit plot number 707 exclusively, and Gopal Kejriwal and Suman Kejriwal got the other non-suited plot exclusively in the partition deed. On the basis of such registered deed of partition, the aforesaid petitioner's investors became owner of the suit plot number 707 to the extent of 1.29 acre, and LRR were also prepared in their name, and they also paid taxes to the BLL and LRO, Tilpara Gram Panchayat, and they have been possessing the same peacefully to the knowledge of all concerned. So the petitioner inventors frequently visited the suit plot number 707 during such recent visit made by them sometime in the month of July 2018. The petitioner inventors saw some person claiming right, title, and interest over the aforesaid plot by way of decree in preliminary form in title suit number 27 of 2007. And after knowing such fact, thereafter the petitioner inventors came to court and contacted to the learned lawyer and disclosed the case matter, and the learned lawyer searched the case record of TS number so and so in the court of the Civil Judge Senior Division at Shiv. It is revealed that the plaintiff got a decree to the extent of 5/18 share in the preliminary form, and also revealed that the final decree of partition already filed before the learned court. After hearing the learned court has been pleased to allow the partition and appoint Sri Subhash Chandra Mondal, advocate, as a survey pass commissioner, and the said learned advocate holding local investigation over the suit plot and other non-suited plot. And a report was submitted before the learned court, and it also revealed from the said report that the plot number 707 already transferred by registered deed of sale, right number 3663 to the extent of 1.29 acre, remaining 0.06 cent acquired by LA collector. So the plaintiff, after suppressing the material fact, got the preliminary decree from the learned court, and such the plaintiff and the defendant have no right, title, and interest and possession over the suit plot number 707, and the suit plot is not joint and HON'BLE property, and the aforesaid petitioner and inventors are required to be added as the necessary parties in the suit for partition to contest the same. As such, necessary order is required to be passed, and that too for the ends of justice.
So who got the demarcated portion?
No matter the final decree has not been drawn up.
No. From whom you have purchased?
I purchased from the heirs of Ashalata, Shoshti Kinkor, Rabindranath, Sunil, and heirs of Sridhar.
Have you
Paragraph
annexed the deed?
Well, the deed is annexed.
Annexed.
Yes, deed is annexed.
It is annexed. But
Proper. I will give you a lot of a type copy.
type copy.
I will definitely give you a lot of a type copy before passing
Otherwise-
off the order. Yes, I will give you a lot of a type copy before passing off the order. I understand. But this is my case. Number rightly or wrongly, I purchased that property. Whether I purchased a demarcated one, whether Ashalata exclusively owned that plot number 707 or not.
You have purchased 3 bighas, 18 kathas and 32
Yes.
square feet.
Yes, 1.29 acre. In
Uh,
total, 1.29 acre.
56192.
Square meter. I shall give you lots of a type. I undertake. I shall give you lots of a type. Now, rightly or wrongly, may I submit, it is admitted fact, Ashalata is the daughter of Siddheshwar. That is admitted in their opposition. Number, it is also admitted that the Ashalata would get only her life interest over the property. After her death, her sons or daughter will get the Lordship, the
Accordingly, her four sons obtained the
after
property.
the share of the property. But it may be a question, the whether the seven plot number, they will get the entire plot number 707 or not. That is matter of trial in partition. I purchased a share from the heirs of Ashalata. Maybe I may be allotted a different land. But I purchased 707 from the heirs of the Ashalata. I cannot claim better right than my lordship, my transfer, the owner. I only claim right from my owner. The owners has the 1/3 share in the entire property. They sold me 707. Maybe after trial, it may be find out
They sold their entire share.
entire share. Entire share. If your lordship kindly look into the cost title of the appeal, your lordship will not find the detail of the sons and daughter of the Ashalata. Kindly see, my lord, the name of appeal. Who are the plaintiff?
Their names are the names of your transfers.
Sosti Kinkor, Romindranath, Sunil, and lordship the heirs of Sudhir, that is Dulali, and lordship that their name are
Rabindranath Ghosh.
yes, Sosti Kinkor Ghosh, Romindranath Ghosh.
One Rabindranath Ghosh is appearing as appellant number 5.
Yes, but kindly see there is no name of Sosti Kinkor or the sons and daughters of Sudhir.
Yeah. He is the son of Arun Ghosh.
Arun Ghosh.
And Rabindranath and the
Sunil and Rabindranath has been made party.
Sunil. Sunil is, yeah, Sunil 4.
Four. Sunil and Rabindranath gave a party. But you also will not find, I could not find the name of Sosti Kinkor or the daughters and the wife and sons of Sridhar. Their name are Dulali and Sudipto Ashish.
The partition suit was initiated in which year?
In the year, lordship, may I give you the exact date? 2007.
2007. You have purchased it on?
We purchased on 2002, 28 June 2000. Not painted that like the purchase.
No, prior to the
Filing
of the partition.
Yes.
So then the question is now, in spite of purchase of 1/3 share, according to you,
Yes, my lord.
why have you filed under Order 1 Rule 10(2) much later on?
No, my lord, I am not made a party. I could have not, when the partition commissioner appointed, he visited the spot for making the commission work. That time I come to know, I then and there filed this application. I filed the application before the trial court on 20 July 2018.
You have mentioned in your application.
My lord, if you also kindly see my petition, the left hand corner, 28 July 2018. Filed on. Even in my petition, my lord, on oath, I have stated.
In which paragraph?
In paragraph 11.
Paragraph 11.
Yes, my lord. Page 14. Page 13. Start from page 13. Your applicant states that after coming to know about the aforesaid fact, your applicant were advised by the said learned advocate for the learned Shuri court to file an application for addition of party as such on 26 July 2018.
In the application filed before the trial court?
The next page, page 14.
No.
As such, on 26 July 2018, an application was filed by your applicant under the provision of Order 1 Rule 10 Because still possible. The said application is still pending.
In the application filed before the trial court,
Yes, my lord.
in which paragraph you have mentioned?
My lord, page 13, paragraph 11. Page 13, paragraph 11 of my petition, my application.
Hmm. In the application which you have filed before the trial court,
Yes, my lord.
in which paragraph you have mentioned?
The reason for delay.
Hmm.
No, my lord, kindly come, page paragraph 7, page 24. That the
Hmm.
petitioner inventors frequently
Yes,
visit
yes,
the
yes,
suit
yes,
plot.
yes, yes.
Not got it?
Hmm.
Now, my lord, if you will also kindly look into their opposition now. What they have stated in their opposition. Now, my lord, kindly keep over paragraph 1, 2, 3. These are all,
6, my lord.
I bolni didi.
That's
1, 2, 3 are all are formal in nature. Paragraph 4, but this is also a formal. So that's why I'm reading for your lordship. This application is not bona fide. This application suffer from gross suppression of material fact. The application not permissible to be entertained.
Need
At
not,
the-
need not.
Now, my lord, now not kindly come to paragraph 6, page 4,
Six.
paragraph 6. With reference to paragraph 1, 2, 3, and 4 of the said application, I deny the contention therein, save and except what are matter on record. It is denied that there could have been any amicable settlement amongst the 3 daughters of the late Siddheshwar Ghosh, or that there could be any exclusive allotment at the stage of undivided property forming the subject matter of propounded will of the late Siddheshwar Ghosh. The said issue has already been decided by the learned trial court as well as the first appellate court. None has challenged the same. Now, but kindly consider whether the amicable settlement is there or not, whether I will be benefited of amicable settlement or not. That is required time. Now, next matter, it is submitted that the subject matter of the second appeal on forming the substantial question of law does not require the implementation of the applicant. The present application seeks to reopen closed and already adjudicated issue. The order of the learned trial court on the issue 5 and the order of the first appellate court upholding the said order will operate as an issue estoppel and even a res judicata. Before the second appellate court, the applicant cannot certainly apply for impediment or for the addition of parties in the suit in relation to a matter which has not been framed as a substantial question of law for the purpose of admission of second of appeal. This, my respectful submission before your lordship is that when I am before a second appellate court, but this honorable court has ample power to frame a additional lordship substantial question of law. Because in the first step, in the trial court or in the first appellate court, or even at the time of admission of the second appeal, we are not before the court. We are not in the court. Neither were made in party. The persons who sold their share, 7 except 2%, others were not made in party. So my case was not put up before the learned trial court or before this honorable court. With reference to paragraph 5 and 6 of the said application, I deny the contention therein, save and except what will appear from a true and plain reading of the probate will of the late Siddheshwar Ghosh and what may transpire from the record of the suit. I deny the contention therein, save and except what are matter of record. The courts have already declared that the 3 daughters of the testator of the will were life estate owners of the properties in question, and therefore there could not have been any divesting of any right and interest of the said property at the behest of the life estate owner to any third party during the lifetime of the life estate owner. In any event, no unpartitioned property could be transferred or disposed of by any of the legal heirs of the Ashalata Ghosh. In any event, record of right is not a document of title. With reference thereafter, general paragraph has been given, the retaliate everything. They state that, kindly see the paragraph 10. With reference to paragraph 11 to 13 of the said application, I dispute the amendment made there. It is admitted by the applicant that an application for addition of party is still pending before the court below. Is that to be without taking any step of the said application, how this application for addition of party is maintainable after preliminary decree at the second appeal stage. I submit that the contention of the denied, thereafter they paid for rejection. Now, they have 2-fold case made out in their opposition. Firstly, the Ashalata being the daughter of the Siddheshwar, she do not get any life, she do not get any property right over the property. He has only the life interest. She cannot transfer. But I have not purchased the property from Ashalata. I have purchased the property of the legal heirs of the Ashalata by virtue of who became the subsequent owner, the property. Firstly, and secondly, also the entire these issue was never before the learned trial court or the lower appellate court or before this honorable court. But this is a partition suit. But there is no specific estoppel upon cause of action of a partition suit. This is a recurring cause of action. But even if take up argument, if we say that your lordship was pleased to dismiss my application, there will be a situation because I have to file a separate suit. This suit to be heard. Everything will be frustrated on all the matter.
Anything more?
Well, that's all.
My lord, I have stated my opposition, my lord, which I, my learned.
First question. To the affidavit in opposition, you have not challenged the deed.
In opposition, my lord.
Yes.
But my lord, after hearing of the appeal, my lord, at this stage, my lord, additional party is not maintainable, my lord. First point, my lord. Secondly, my lord, I have stated, my learned friend has stated before last.
In a partition suit.
Opposition, my lord.
In a
Yes.
partition suit.
Partition suit, my lord. My lord, I have stated in paragraph 6, my lord, page 4, my lord, in my opposition that there could have been any amicable settlement among the three daughters of late Siddheshwar Ghosh, or that there could be any exclusive allotment at this stage of the undivided property forming the subject matter of the propounded will of the late Siddheshwar Ghosh. The said issue has already been decided by the learned trial court as well as the first appellate court. None has challenged the same, my lord.
1 minute. Sunil and Rabindranath. They are one of the appellants. Not being represented. You are representing. Sunil and Rabindranath.
কল্পনা তো মারা গেছেন।
কল্পনা মারা
হ্যাঁ, substitute হয়ে গেছে।
তোমার সাবস্টিটিউট হয়েছে।
Appellant number 4 and appellant number 5. Sunil Ghosh, Rabindranath Ghosh. So be prepared. Be prepared to give respond to the application.
I am not nothing to say, Mr. Sivas.
You will get the opportunity. I'm stating that get prepared to state your objection. Because you are representing
Yes, yes.
Sunil and Rabindranath, from whom the petitioner is claiming to have purchased the property. Yes, so you are not challenging the deed, first of all. You are stating that at this stage, they cannot be implemented as party.
Yes.
Apart from this thing,
Apart
Any
from this,
other?
my lord, this is the undivided property, my lord. I have stated.
they could not have purchased specific portion of the property. As it, according to you, as at that point of time, it had been undivided one. Any other point?
And my lord, I have stated in fact in page 5, my lord, that the order of the learned trial court on the issue number 5 and the order.
Which paragraph, which paragraph?
My lord, paragraph, my lord. My same paragraph, paragraph 6, my lord.
Yes.
Page 4.
Page 4,
Page
paragraph,
4,
yes.
and on the fourth line, my lord.
Mhm.
The order of the learned trial court on the issue number 5 and the order of the first appellate court upholding the said order will operate
One
as
minute,
issue
one minute,
established.
one minute, which portion?
On the page 5, my lord, top, my lord, from my lord, fourth paragraph.
Of your objection?
Yes, ma'am. No, opposition,
Fourth line.
fourth line. Paragraph,
Page 5,
Page
paragraph
5,
6.
top.
Paragraph 6, page 5, fourth line.
Fourth
The
line.
order of the learned trial court.
On the issue number 5 and the order of the first appellate court upholding the said order will operate as issue established and even as res judicata. Before the second appellate court, the applicants cannot certainly apply for increment or for addition of party in this suit in relation to a matter.
How can
which
that be?
is
How can that be?
after, my lord,
Were they,
partition, my lord, this is a partition.
learned
suit.
counsel, learned counsel. Were they parties
Yes.
before the trial court and the first appellate court? Were the petitioners parties before the trial court and the first appellate court?
Applicants.
Applicants? No. So,
But after, my lord,
they were,
very decree, my
according
lord,
to,
after
according to,
1 year, my lord.
according to them, they were not aware of the facts as regards to partition. They came to know when the partition commissioner came into play,
But my lord,
according to them.
yes, my lord. My lord, preliminary decree passed in 2013, my lord. 26 July 13, my lord, preliminary decree passed. First appeal order was passed, my lord, 22nd March 17, my lord.
1 minute,
Yeah.
1 minute, 1 minute. Preliminary decree
Passed on 26 July
26
13.
July 2013.
13. First appeal order, my lord, passed on 22nd March 17, my lord.
1 minute, 1 minute. Passed on 17
22nd March 17,
or 22nd March,
17, my lord.
22nd March 2017.
Yes, my lord. And they have filed, my lord, after 1 year, my lord, July 18, my lord. And my lord, in the long period, my lord, he has no knowledge, my lord, from 13 to 17, my lord.
2018 they have filed.
Yes.
So, if we take into consideration that they had the knowledge and they did not prefer to get themselves impleaded as parties, can they be prevented now?
And yeah, after my lord, closing their appeal hearing, my lord, and after submission of the
Learned counsel will have to keep in
as
mind,
lost.
we'll have to keep in mind the nature of the suit. What is the nature of the suit?
Partition.
And you have not challenged the deed. It is not your contention that they have not purchased.
But all the points have been decided in the trial court and also the appeal court, my lord.
So
And I have
If,
filed,
if they are not allowed, if for the sake of argument, if they are not allowed, then
right to come.
then can justice be provided?
And
The learned counsels, all three of you, we are in the, what is the suit property?
Landed property.
Landed property having how many dark numbers?
Several.
Several,
several.
of which 707
707 is also.
is a part.
Yes, included.
Yes. Anything more to be submitted, Learned Counsel? Yes. For the appellants.
Yeah, I am not just say anything, my lord, because Mr. Vastav is there. But earlier occasion, learned counsel says that if additional party is allowed or not, I'm not saying anything.
Keep in mind that you are representing two of those persons
Because
who have transferred their entire share.
it's my.
That's why he's not appearing.
Instead she is opposing their prayer.
I know, my lord.
Her clients have not transferred their share. Your clients have not
No,
transferred their.
yes.
Your clients.
No, my
His client has
is
transferred money.
two and another others.
My client transferred. Your client Ashalata, your client.
The legal heirs of Ashalata, four sons of Ashalata,
Four sons of us.
who are representing the four sons of Ashalata.
All দুজন বাদে তো বাকি সব আপনি অ্যাপিয়ার করছেন।
Okay, Learned Counsel,
অ্যাপিয়ার করছেন।
you will get the opportunity.
দুজন যে সাবস্টিটিউশন হয়েছে দুজনে হয়েছে।
On Friday,
As well as,
you are shaking your head. You
Yes,
will have,
yes.
you will have to provide the type copy of the deed
oh, Friday, well, I
By Friday.
shall try,
by Friday.
I shall try, my lord.
On Friday, the matter will be taken up.
ফার্স্ট
Only,
10:30
no, not, during this afternoon session. And you will only get the opportunity. No other person will be given the opportunity. We have heard, it has been heard.
ওই আপনার অ্যাপ্লিকেশনটা দিতে হবে, অ্যাপ্লিকেশনটা আমাকে টাইম কপি দেন।
Apart from Robindranath and Sunil, who are the other two legal heirs of Ashalata?
Ashalata has had four sons.
Four sons, according to you.
Yes. Kosti Kinkor, Romindranath, Sunil.
maybe chart
Is there? 1 minute. That will be required.
is submitted before. One chart is
What prevented you from appearing at the early stage? It was about to be completed. Argument was about to be completed.
all
Suddenly you have cropped up.
I filed in 2020. Application was filed.
If one sleeps over his right,
My lord knows the situation of the civil courts, the clients of the civil courts.
then the consequences will have to be faced. If anyone sleeps over his right.
Next to আবার একটা জজ সাহেবকে দিয়ে দেবেন। হ্যাঁ,
No, once it has been provided, it won't.
সিঙ্গেল পেজ মানে
আগের দিন appellant ঢুকলো।
আগে
কাগজ
অনেক আগে
দিয়েছে।
মানে আমাদের যখন আর্গুমেন্ট চলছিল।
Well, they will submit, right? The document does not require to look into further.
Go through the record.
Hey,
If it is available,
আর কোনো কাগজ
then
নেই,
you need not furnish.
আর কাগজ নেই তো ওইগুলি সহজ পেপার বুক
This one,
no no no
not this one. So, a type copy of. One minute. Another page is peeping out. Go through the entire record if it is available, then otherwise,
I
furnish another. And the learned counsel representing the applicant or applicants?
Applicants.
Applicants, which are, can
4 of 2020.
can 4 of 2020,
20.
can 4 of 2020,
আপনারা আবার-
old number, old number,
Old number is, my lord,
1827,
1827 of 2020.
1827 of 2020.
দশ সাহেবেরটা ঠিক করা
ঠিক
যেখানে
করেছি,
দেখে
ঠিক
নিই।
করেছি, ওটা ঠিক করা আছে। পরে ঠিক
আমারটা ভুল
করেছি।
হলেও অসুবিধা নেই।
হ্যাঁ, ওটা পরে ঠিক করেছিলাম, হ্যাঁ। আর আপনারটা করে দিন তো।
তখন
From
একটা
the
না দিদি, আমাকে
causes-
তার
ঠিক
দশ
ঠিক
সাহেব
transpires, from the causes to transpires that the application being Can 4 of 2020 has two old Can numbers instead of two. The correct Can number is old Can number, the correct old Can number is 1827 of 2020. In such circumstance, department, IT. Department is directed to do the needful. হলো? এটা হলো একটা paragraph. The learned counsel representing the applicants submits that the applicants have purchased the entire share, the area.
1.35 acre.
1.35 acres of land in Dag number 707.
07. RS plot
RS plot number 707. Dag number, Khotian number,
number.
Mouja,
Moja, may I give you the detail? Moja Tilpara, my lord.
Mouja Tilpara,
Clear number.
within district of
Birbhum.
Birbhum, within district of Birbhum, from the four sons, namely
Shoshti Kinkor,
Shoshti Kinkor,
Rabindranath, Sunil, and heirs of Sridhar. Fourth son, Sridhar died.
oh, not from Sridhar, heirs
Heirs
of
of Sridhar.
তাহলে তো আবার অন্যভাবে লিখতে হবে।
But if you also it is Daniel read right the
1 minute.
heirs of Asalata.
ষষ্ঠী তারপর
সেটা পুরো আরম্ভ হলো।
Sunil আর Sridhar.
From the three sons of Ashalata, namely, from the three sons of Ashalata, namely, and the grandson, the granddaughters,
Wife of Sridhar and two sons.
and the wife of and the wife and two sons, of Sridhar, who was the fourth son of Ashalata.
Yes.
Full stop. The legal heirs, he further submits that the legal heirs of Ashalata through this deed of indenture had transferred their entire share in the property. Full stop. He further submits that after the preliminary decree been passed and the judgment and against the said preliminary decree, first appeal being preferred, and after the passing of the judgment by the first appellate court, at the time of partition work by the partition commissioner, the petitioners came to be aware as regards to the partition of the said property. Full stop. Being aware of the partition proceedings, the applicants, the petitioners herein preferred an application before the trial court in the final decree, in the proceedings for final decree. Full stop. And the full stop, and has also filed this application in this present appeal. Full stop. He further submits that being a co-sharer of the disputed property, in the disputed property, the applicants are required to be made parties in this appeal, in this list. Full stop. Learned counsel representing the respondent, all the respondents, representing the respondents, has filed an affidavit in opposition. You have received copy of the affidavit in opposition? You have received copy of the affidavit?
I have not served, my lord. I have only, yes, my lord, I will serve.
During the course of this day, a copy of the affidavit in opposition has been served upon the learned counsel representing the appellants and the applicants. Let it be kept with the record. Full stop. Learned counsel submits that preliminary decree has been passed on 26/7/2013, and the first appellate court has been pleased to pass the judgment on 22nd of March 2017. Till that date, the petitioners had not preferred any application and had not prayed for being incorporated. Later on, they have come up, but they have preferred the application seeking to be included as parties, which is barred by the provision of limitation. Full stop. She further submits that at that relevant point of time, there had not been any demarcation. So, how could the applicants, petitioners, purchase the property situated in DAG number 7, plot number 707? Full stop. Banking upon the aforesaid submission, the learned counsel seeks for dismissal of the, for rejection of the prayer made by the applicants. Full stop. Paragraph. At this stage, the learned counsel representing the appellants seeks an accommodation. Full stop. Consider the submission. Let the matter appear on next date, a Friday.
Friday, my lord, sir, after 2 p.m.
After 2 p.m. Most probably. As such, I am unable to
Give the exact date.
mention the date.
I did too.
My lord, I am giving copy to copy can read it.
Oh, Friday 28th, no. 2700.
Will be available.
আর কোনো ডকুমেন্টস আছে?
And this bench is available.
অনেক ফাইল ছিল তো।
এলসি একটা আছে না? এলসি একটা আলাদা আছে।
এটা তো court record।
আচ্ছা, আমার ভাই তো বিশাল ছিল।
হ্যাঁ, 5-6টা অ্যাপ্লিকেশন ছিল,
একসাথে।
একটাও দেখতে পাচ্ছি না।
ডিসপোজ অফ হয়ে গেছে বলে সরিয়ে দিয়েছে।
অনেক কাগজ ছিল।
Go through the record today.
ঠিক আছে।
একটু খেয়ালে ওনাকে দেখি।
Check.
Next.
Number two, I am appearing on behalf of the appellant, my lord. I have concluded my submission, my lord. I'm on behalf of.
Kindly make it not today.
Several of times they are
Led
taking
by
time, my
Mr.
lord.
Gopal Chandra.
Request Mr. Ghosh to be prepared on Friday and submit during the second session. This bench will be available on Friday during the afternoon. So request the Honorable Senior Counsel to be prepared on Friday during the afternoon session.
Afternoon. Yeah, grateful, lord.
No, no. No, 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 no. বন্ধ করুন।